Hi girls. So in today's class we'll see the continuation of the Patents Act. Okay. So one important topic from Patents Act will be the procedure to grant of patents. So in your textbook it is explained in detail, so which is not necessary. So if at all asked, it will be asked for 14 marker. So always try to concise the answer and write. So I have made jot down these points. Okay, so you all can look into this as a reference and takes information from the textbook and try to write the procedure for the grant of patents. So this is one important topic from examination point of it. They've asked this topic quite a few times. So let me explain this topic to you. Procedure to the grant of patents. So we have seen in the previous video what patents is and what are the advantages of obtaining patents. So now we'll see the procedure for obtaining patents, how the authorities, the government grants patent, what are the procedures, what are the steps that which is involved in the process of grant of patents. So I've jotted down and given you as different points. So as you see, first one, application for patents. So first thing that you have to do is you have to apply for patent. Okay, so which will be done formally in the form of a or filling up of an application form. But before that, who can apply for patents? Okay, so what is the description at which you can apply for the patents? First person, okay, to apply for patent will be the true and the first inventor. So if you are the true and the first inventor of something where this particular thing was never there in the nature or it was never there in the society, and you have invented a particular thing for the very first time, then you have all the eligibility to apply for patent. Okay, so a person claiming to be the true and the first inventor can apply. So apart from that, an assignee of the person can also apply. So who is an assignee? Someone who is assigned by the person who has found the invention. So he can also apply, okay, for the invention. So assignee can be some legal representatives or it could be a business partner. Okay, so basically the person who has invented will appoint the person to or assign that particular person to do the file for the application. Then apart from that, legal representatives of the deceased person. So deceased, when you call somebody deceased, is when the person is no more. So supposing the person has been involved his entire life in finding out something novel, new, discovering something, and before he could even apply for patents, if he is no more, then the legal representatives can always apply, okay, for the on behalf of the deceased person. On the deceased person is none other than the one who is no more. That's when you'll call somebody deceased. Okay, so he also can apply for patent. So other than this, a company can also apply for patents. All this will come under who can apply for patents. So a company or firm can also apply for patents. So as a company, as a group of people, if they have found out something, okay, it could be anything. It could be a design, an art, a methodology, okay, something that which is novel, new, anything. So if as a company something is found, so they can also apply for patents. Then government servants can also apply for patents. So there are two different types of government servants. One is state government servant, another one is central government servants. So either of them can apply for patents. Okay, apart from that, defense personnel can also apply for patents. Okay, so defense personnel, those who work either in different types of defenses like army, navy, anything, so they can also apply for patents. So that's your who can apply for patent. Now next thing is, where should you apply for patents? So patents should be applied for, okay, at the patent office. So this patent office is basically established by the government of India. Okay, so they are given the authorization. Okay, so the legal what to say, the authority to grant the patent. So obviously this patent office will have certain representatives from the government, okay, so who are nominated, and they can grant the patent. So basically this particular patent office is located at Calcutta, and that is the head office, okay. And apart from that, yes, here and there would be branches in order to grant the patent. So it is the one which grants patent. This is the office which is given the authorization to grant the patents, but obviously undergoing a lot of procedures. Then now talking about the application form. So this application form, okay, has to be done for one invention only. Okay, so that means every application should be made only for one particular invention. So if a person has made more than one inventions, then obviously each invention should be applied in individual application form. Alright, so now every application should be accompanied by provisional and complete specification. Okay, so what is this provisional and complete specification in the sense? So provisional specification is nothing but it's like an abstract, that which is submitted, okay, before the in detail description is submitted. See, now there are two different types of descriptions. One is called as the provisional, okay, another one is called as the complete. So first specification is called as the provisional specification, second one will be called as complete. So this provisional will be done in the beginning, okay, so where the application is made. Now when along with the application, rupees 20 has to be paid as processing fees, okay. So now maybe earlier it was like that, now maybe the application fees is increased. So according to your textbook, 20 rupees should be paid along with the application form, and also the provisional specification. So specification is nothing but the description, okay, it's an abstract of whatever invention that you have done, which will explain the invention in detail. So that has to be accompanied, okay, and that is along with the application form. And talking about some more acknowledgements that has to be there along with the application form will be power of attorney, okay, on a stamped paper. So what is this power of attorney? So it's basically where the like for example, I told you that when a person applies for patent, okay, so not just the inventor can apply, even an assignee can apply. So when you are appointing an assignee, you need to give the power of attorney to that particular person. So power of attorney is to give the powers to sign, basically to take decisions and so on. So that particular certificate of giving the power of attorney should be submitted with the patent office, and that has to be on the stamped paper along with power of attorney. Now if at all the person himself is applying, there is no need to submit the power of attorney. But another important acknowledgement with the application form will be the specifications. So now I told you, first thing is, when the application is made, along with the application, the specification, that is a provisional specification, should be submitted. And after 12 months, the complete specification has to be submitted. Okay. So now talking about the specification here also. So when the specification is accompanying, rupees 20, okay, should be given as a processing fees. This is for provisional. And when complete specification is being submitted, rupees 50 processing fee should be paid. Okay, it's considered as a fee along with the application form. So now these specifications become important, all right, because they are going to have some details like models, illustrations, methods, okay, and the complete abstract of the technical information will be given in these specifications. Okay, so going through the specifications only, one will be able to understand what the invention is, what the novelty is, and they will also be able to understand technically in detail how it was found out, what was the method used, okay, everything will be explained in detail in this particular specification. All right, So that is about the acknowledgements and specifications. Now the next process will be examination of the application form. So now the patent office should examine the application form. So what are they going to do, or how are they going to examine? First thing is the patent office will examine, okay, that is the controller in the patent office only will examine the patentability of the invention, whether the invention is patentable or not, meaning whether it can be given patent rights or not. Okay, so they are going to check whether the application and all the specifications relating to is in accordance with the rules and regulations of the Patents Act. Okay, so anything offending the rules and regulations of the Patents Act will not, the application will not be considered, it will not be accepted. And they should also see whether there is any grounds on which the patent is to be objected, meaning rejected and not granted patent. Objection is when a patent application is rejected and not granted the patent right. So they have to see look for the grounds to grant the patent rights as well as not grant the patent rights. And then they should also check with all the results of the investigation that was just made. Okay, whether it is already there, whether it is priorly claimed or not. So any other matter that which is subject to the prescriptions, everything should be checked when the application is going to be examined, otherwise calling it as scrutinizing. Okay, so also in detail the specifications will be checked. Alright, so now if at all it is found that the application is absolutely fine and it is acceptable, then they are going to accept the specifications. Now I told you that the specification will be given or submitted in two different dates and in two different forms. First one is the provisional, which will just be the abstract, okay, so where it will be done along with the application form initially, and later after 12 months or within the time of 12 months the complete specification should be submitted with the patent office. So if everything is fine and it is acceptable, then they are going to accept the complete specification. Okay, so which will be given after 12 months, and it will not be an abstract, in fact it will be an in detailed description of the entire patent, entire invention, novel, okay, novelty, right. Now next thing that they will do, they accept, if the complete specification is accepted, next thing that they will do is grant the patent. So granting of patent, though we are seeing is a procedure involved, this is a particular procedure involved in the grant of patent, it doesn't just stop here. After this also there are other steps which are involved in the grant of patents. So let's see now what is grant of patent. So once the complete specification is accepted, the controller shall advertise this acceptance in the official gazette. Official gazette is nothing but the official magazine, okay, of the patent office. So patent office will have periodically its official magazine which will keep on advertising their applications and the inventions, the methodologies and things like that. So people will also see that, okay, read that official gazette, and not only that, they will also allow the application, that particular thing to be kept for public to come and see. It will be kept as an exhibition for public to come and see. So not only they are going to officially declare in their gazette, but they are also going to keep the particular invention open for public inspection, where anybody can go and see that invention and they can check it out whether it is a new, novel and things like that. Now next thing will be opposition to the grant of patent. Now after it is being published in the official gazette and after it's kept for the public to inspect, within 4 months from the date of advertisement, okay, of the complete specification, they should try to bring the opposition. For 4 months, if there is no opposition, then the date is barred. Nobody can oppose that particular invention. Okay, so within 4 months period of time from the date of the grant of patent, that is the after they put it in the official gazette and kept for public inspection. So within 4 months there should be opposition, that which is coming from whoever it is, from the opposition party. Okay, and if it is after that, definitely it will not be granted. Now, supposing at the end of 4 months, if it is found that a person suddenly gets to see, then he can maybe apply for the extension of time. After 4 months, extension of time, so which can be given at the discretion. Okay, and for which rupees 25 should be payable. Asking for extension, rupees 25 should be payable to the patent office. All right, now let us see the next point, that is the opposition to the grant of patent and the grounds of opposition to the grant of patent. I mean, like I already told you what is opposition to the grant of patent. Now we'll see the grounds of opposition to the grant of patent. What are the grounds? Okay, what are the bases on which a person can bring is opposition, is what it means. Now, first ground is when the invention is wrongfully obtained. Okay, it is not his invention at all. He has robbed somebody's invention, he has snatched somebody's invention, and if he is claiming, then it is called as wrongful obtainance of the invention. So if it is found that it is wrongfully obtained, then you can come and oppose. The next one, that invention is so far is claimed and the complete specification is not satisfactory. Okay, if it is the complete specification was not given on time, as well it is not given completely, if it is not satisfying the requirements. Okay, so even then it can be opposed. Now, complete specification was already known. Come on, like this particular invention is already there in the society, then again a person applying for it. Okay, so that thing also can be opposed. And if it is found that there is no invention, there is nothing inventive, that nothing novel is there in the invention, even then it can be opposed. Now, if an invention is not within the meaning of this act, or it is not at all called an invention, even then it can be opposed. Or if the complete specification is not sufficient, it's not giving clear details, okay, as to how it is performed, what is the methodology. Sometimes some people will claim it as an invention, but they won't tell you how it was invented. They won't be able to practically prove the invention, isn't it? So then also it can be opposed. All right. So like this, they're different. Now, for example, also if that it does not belong to that particular geographical origin, so somewhere else, some other country it is belonging to, and you are coming and claiming that it is belonging to your country. So like this, there are different grounds on which opposition can be brought forth on whoever is opposing. Okay, so that is called as the grounds on which you will be able to bring the opposition. So the next one is the notice of opposition. So what is this notice of opposition meaning? The opponent must give the notice. Whoever is opposing, no, he must give the notice of objection in a particular form which is required, like it's called the form 15, to the controller of the patent office. All right, and it shall be given, this particular copy shall be sent even to the applicant of the patent, whoever has applied, no, and then they will also be sent the notice that this particular objection has come. Then just like how in the court of law they will have hearings, no, now the patent applicant as well as the opponent, both of them will be called by the patent office for a hearing. Okay, both of them and their point of it will be heard. So it's not that a person will just be heard on one side and the other person will be given some kind of justification. Now that a person has made the application, is the applicant of the patent, another person has objected the same. So the patent office, a controller, will call both of them and hear from them and then decide whether it has to be objected, not objected, and then they will give the justification. Now supposing in the hearing it is found that the applicant is right, then obviously the next step is the grant of sealing of the application. Okay, so the granting and sealing of the patent. So If it is all satisfactory, if everything falls in place, and if everything is according to the act, and if everything is within the meaning of this particular act, not rejecting or opposing any rules and regulations, if it is found satisfactory, then the patent will be granted and it will be sealed. Okay, so this will happen according to section 25 under the act. Okay, so the application, this will happen in two situations. First thing is when the application has not been opposed at all, there was no opposition, and it is satisfying all the requirements. And the second situation is there was an opposition but it's in favor of the applicant, then the procedure, okay, I mean the patent procedure will be granted. So after this, whatever you find in your textbook, it's not required, girls. You can just strike it off. Now next thing that we will see is the restoration of the lapsed patent. Okay, so what is a lapsed patent? In the sense that, see, every patent will have its own lapsed period of time. Okay, so like to a certain extent or to a certain period only it will be granted, and you have to keep renewing, okay, your patent, and that is what is called as restoration. If the renewable is done, who has to do this? Again, it should be done by the person who has applied for the same. Okay, so it is basically to I must say, it basically is to bring some kind of amendments or changes on the on the patent, or because the time limit has been expired, and again it has to be renewed to continue to enjoy that particular patent right. So whoever is given patent right now, he has got every right to sell his invention, to make business out of his invention. So that also will be granted for a limited period of time. Okay, say for example 5 years and things like that. So after the lapse of 5 years period of time, again this person should renew his patent right. Okay, otherwise he will not be allowed to sell his invention. So that is nothing but the renewal of the patent right is nothing but restoration of the lapsed patent. Okay, so if you allow it to lapse, that is if the time limit is barred and if the patent is not renewed, then it will become a lapsed patent. Did you understand? So you need to renew it according to whatever is the time limit given. Okay, now next thing will be surrender and revocation of patents. What is surrender? Surrender means, as the very meaning says, it is done by the applicant of the patent itself. Okay, so where he comes to the patent office and surrenders his patent thing and revocates, that is cancels, nullifies his patent. Okay, if he gets back to the office, I mean the patent office, and if he is cancelling his thing and surrendering his patent right, that is called as surrender and revocation. Okay, so this can be done on following grounds. Why should a person surrender? What makes him surrender? So first thing is, it could be brought or it could be revocated in the public interest by the central government. The central government finds, okay, this particular publication should not no more exist, it should better be surrendered, okay, and nobody else should use it, and if it's for the public interest, then it will be submitted. Atomic energy is also, they're dangerous in nature. It can claim the life of people, it can really be exploiting in the environment. So again, there also it may be asked. Now if it is found that a particular invention is not working at all, it's not used, nobody is using it, so then also you will be asked to surrender that particular patent. Sometimes the inventor himself, out of his own choice, for various reasons, can come and surrender his invention. So sometimes it is forced upon, where the court declares that this particular invention should not be in use for various reasons, then again it will not be used, it will be revoked. it has to be surrendered. Okay, so personal interests of that particular applicant. So like this, there will be many reasons as to why the patent is surrendered. So that is called as surrender and revocation of patents. So this much if you would write for the procedure, the grant of patent. Actually, the procedure for grant of patent will end here. Apart from that, you have two more topics which I've just discussed with you, the meaning of that, and that is enough. So that's sufficient. So that's made as mentioned in the syllabus. One is the restoration of the lapsed patent. Another one is the surrender and revocation of the patents. If at all they ask you for 2 marks. Otherwise, most of the times the procedure involved in the grant of patent only is asked. So if you would jot down the procedure involved in the form of these points, so you would be able to write it easily. Okay, so please do watch this video and also refer your textbook. You will be able to find relevant information, and accordingly you will be able to understand the topic. If at all you didn't understand anything here, please get back to me to clarify on your doubts. Thank you.